Hello everyone, a very good evening. Welcome to Oliveboard, and today we are going to start with the unit 4 of our module A of BRBL paper. So this series is the CAIIB Foundation July 2025, and we are summarizing all the units module wise. And today we have the unit 4, which is returns, inspection, winding up, mergers, and acquisition. This is quite a lengthy chapter, but we have summarized, we have included the most important sections, the most important topics that are crucial from our exam point of view. So let us start with the unit 4 of our module A. Again, we have already completed the first 3 units, and all of these videos are available on the YouTube channel, so make sure that you watch them. Also subscribe to the channel so that you do not miss any of the updates. Now let us start. All right, so this chapter basically talks about the various returns that the banking companies, foreign banks, the non-scheduled banks, they're required to make, right, under the Banking Regulation Act, right? So first we have all those banks who are listed with stock exchanges. They have their shares listed with stock exchanges. They're required to publish their unaudited quarterly results. So when we are studying this chapter, first we need to see the different types of returns, the section, and then when, at what time do they require to publish it. So those banks that have their shares listed with the stock exchanges, they're required to publish their unaudited quarterly results. So on a quarterly basis, as per the format that is prescribed by SEBI. Why SEBI? Because we are talking about the shares and the stock exchanges. And every banking company has to prepare its balance sheet, profit and loss account, which is stipulated in section 29 of the Banking Regulation Act. So when we talk about the financial statement, so the profit loss account, the balance sheet, other things that are included in it, everything will be prepared. Then when we talk about the foreign banks, right, their wholly owned subsidies or subsidiaries or the branches that are operating in India, they are incorporated outside India, right? They have to display in a conspicuous place in their principal office a copy of the last audited balance sheet and profit and loss account. So apart from the other returns that they are needed to provide, or they needed to submit, they also need to present this copy of their last audited balance sheet, right? So when we are talking about the banks whose shares are listed with the stock exchanges, the balance sheet and the profit and loss account, it has to be prepared at the end of each calendar year, or we'll say the expiry of the 12 months period, whatever is specified, right? Then the balance sheet and the profit and loss account of the banking company incorporated in India, it has to be signed by whom? The manager as well as the principal officer of the company, and at least 3 directors. All of this information is important. If there are more than 3 directors, right? And if there are less than 3 directors, then it has to be signed by all of them, right? If there are more than 3 directors, then at least three. And if there are not more than 3 directors, then all of them. By all the directors, it has to be signed, right? Then we also talked about the foreign banks, right? And that is there. Next, if we take the case of the functions, duties of the auditors and liabilities, penalties that they are subjected to, these are given under section 227 of which act? The Companies Act of 1956 or section 143 of the Companies Act 2013. It is applicable to the auditors of banking companies also. So who is going to conduct the audit? The audit and the auditors. The auditing of banks is given under which section? Section 30 subsection 1 of the Banking Regulation Act, that to conduct the sound and robust audit function in the respect of accounts of the bank, right? Then what are the powers and functions of the auditors, right? They need to see whether or not the information that has been provided, it is explained in a correct manner which is required, it is found to be satisfactory. Then whether the transactions of the company, they are given correctly or not, whether the returns that are made from the branches were adequate for the audit, profit and loss account, do they show the true picture, right? Any other matter that the auditor feels or they consider necessary, to bring to the notice of the shareholders of the company. These are all the functions of the auditors, right? So, safeguarding the interest of the promoters, then responsibility towards the public, depositors, all the stakeholders, these are the responsibility of the auditors. Now, there's another important concept which is known as a special audit. This is given under Section 31B of the Banking Regulation Act. Section 30 talks about the audit, right? Then Section 30 subsection 1B talks about the power which is given to the Reserve Bank of India. RBI is empowered under this section to order a special audit of the accounts of any banking company. So when the central bank is of the opinion that special audit is necessary in the public interest or in the interest of the banking company or its depositors, and it is binding on the banking company, if RBI says that we need to conduct this audit, the banks, they cannot reject it, right? And all the expenses, this was asked in the previous year question as well, that all the expenses in relation to the special audit will have to be borne by whom? Borne by the banking company. So all the charges, all the expenses will come under the banking company. All right, this is regarding the special audit. Then what all returns have to be submitted. So return has to be given on the liquid assets. So every banking company has to submit a return on its liquid asset under which section? Section 24 subsection 3 of the Banking Regulation Act. And this return has to be submitted within 20 days from the end of the month to which it relates, right? So for every month, this return of the liquid asset has to be submitted and within 20 days from the end of the month. And this has to be according to the form which is prescribed under Rule 13A of the Banking Regulation Companies Rules of 1949. All right, so these sections are important. Section 24, subsection 3. So it should contain the particulars of the assets and the demand and time liabilities, right? And Reserve Bank can also ask the banking company to furnish returns showing particulars of certain assets at the close of each day of the month as well. Then we also have returns regarding the monthly, right? So monthly returns. This is given under section 27, that a banking company has to submit to the Reserve Bank a return under section 27 of the Banking Regulation Act, showing its assets and liabilities in India as at the close of its business, right? So on the last Friday of the previous month, that is the closing. So last Friday of the previous month, every month the banking company will have to submit this return. So it is a monthly return. All right. Then regarding the accounts and the balance sheet, annual accounts and balance sheets have to be submitted to the RBI within 3 months from the end of the period, right? Regarding the return of assets in India, regarding the unclaimed deposits that we'll be covering in other chapters as well, the return of cash reserve of the non-scheduled banks, all of these things are there. When we talk about the return of scheduled banks under section 42 of the RBI Act, the scheduled banks have to submit returns to the Reserve Bank of their demand and time liabilities, which is specified in the subsection 2. So section 42 talks about the returns that have to be submitted by the scheduled banks. Then if we talk about the preservation of records, and the return of the paid instruments, this is given under section 45Y of the Banking Regulation Act, that the central government may, after consultation with the Reserve Bank, make rules specifying the periods for which a banking company shall preserve its books, accounts and other documents, and a banking company shall preserve and keep with itself different instruments that are paid by it. Like when we'll be talking about the Prevention of Money Laundering Act. So to ensure that the accounts are all the information is maintained, then for a certain period all the transactions above a certain limit will be maintained, the documents will be maintained, even after the closing of the account the documents will be maintained, right? We will study this in detail when we study the Prevention of Money Laundering Act. in the next module, right? Then if we talk about the information that will be preserved, like the all cash transactions of the value more than rupees 10 lakhs or less than 10 lakhs, but in a particular month it accumulates to rupees 10 lakhs, non-profit organization value of rupees 10 lakhs. We'll see this in detail when we study the particular chapter. Regarding the return of the paid instruments as well, right? So again, section 45Z of the Banking Regulation Act, the bank is authorized to return the paid instruments to the customers even before the end of the period of the preservation which is specified under the act, right? Then if we talk about the special audit, right? The special audit which is given under the powers to RBI. RBI is empowered to conduct special audits. So for that, all right. Next we have the Board for Financial Supervision. So this was made the Department of the Banking Supervision, DBS. It empowers the RBI to inspect and supervise the commercial banks. This department was created by RBI, so RBI indirectly conducts the inspection and supervision. The Department of Banking Supervision was tasked with the inspection and surveillance functions relating to the commercial banks from 1993. Before 1993, separate departments were working for different areas, right? But now all the credit institutions, it includes the scheduled commercial banks, cooperative banks, local area banks, NBFCs, SFBs, everything. Before that, different departments were working. Like there was a different department for banking supervision, department for the non-banking supervision. Then the department for cooperative banks was set up, right? These things were there. If we talk about the constitution and composition, again we have the details about this department in another chapter that we'll be covering there. Like the governor of the Reserve Bank of India is the chairman of the board. Then there are the deputy governors who will be the members. Then four directors are also nominated from the central board of RBI, right? So these things we'll be seeing in detail. But for the supervision, this department has been set up. Functions again for the supervisory process, off-site surveillance system, all of these are the common functions that we already know. Meetings, this board is required to meet normally every month. So monthly meetings will be conducted by the department, right? Then if we talk about the Daksh portal or a new initiative that was launched. So this is the Reserve Bank's advanced supervisory monitoring system, right? So in 2022, RBI announced launch of a new initiative named Daksh. It is a web-based end-to-end workflow application through which RBI shall monitor the compliance requirements in a more focused manner with the objective of further improving the compliance culture in the supervised entities like the banks, NBFCs, etc. So it is a web-based digital solution, we'll say, right, for better compliance, better monitoring that all these regulated institutions are working according to the guidelines that are issued by RBI. So Daksh initiative, it is an important initiative that was taken by RBI. So it enables communication, inspection, planning, and execution. If there is any cyber incident, so reporting and analysis, management information system reports, right? Anytime, anywhere, secure access is provided. So this was for the inspection, audit, and so on. Then we have the acquisition of undertakings, right? We have the amalgamations, mergers, all of these options are there. Like who has the power to make a scheme for the acquisition? So the central government is empowered to make a scheme for any acquired bank. Then such scheme is to be framed in consultation with the Reserve Bank. These are some things that we already know, right? So The central government can acquire the undertakings of the banking companies in the certain cases, which is given in the section 36 AE of the Banking Regulation Act, right? So any bank will be acquired on upon receipt of a report from the Reserve Bank if the central bank is satisfied that a banking company has on more than one occasion failed to comply with the directions which are given to it under section 21 or section 35A, such as relating to the banking policy, all or it is being managed in a manner which is detrimental to the public interest, to the interest of the depositors. If it is in the than that in the interest of the depositors of such banking company, in the interest of the banking policy for better provision, if the central government is satisfied that yes, these reasons are there which are stated, that the bank is not complying with the directions, or they are acting in a manner which is detrimental to the interest of the public, it is against the public interest, then the central government can order for the acquisition, right? So if it is necessary to acquire the undertaking of such banking company, then the central government may, after consultation with the Reserve Bank, they can acquire the undertaking with effect from the date which is specified on behalf again by the central government. So central government is empowered for the acquisition, right? There are also the cases of amalgamation of banks. These amalgamations can be voluntary, or the amalgamation can be by the government, moratorium and amalgamation. So a banking company may be amalgamated with another banking company under the section 44A of the Banking Regulation Act. So voluntary, on their own. For this purpose, again, a scheme has to be prepared. Then this draft will be placed before the shareholders of the two companies separately. It will be approved by a resolution which is passed by the majority of the members, right, representing two-thirds of the value of the shareholders. If it is not approved, then another plan can be presented, or we'll say that the amalgamation can be cancelled or it will be accepted if it is approved, right? Then amalgamation can also be done by the company. So the central government is empowered to order amalgamation of two banking companies. This is under the section 396 of the Companies Act 1956. Again, this decision of the central government has to be in consultation with the Reserve Bank. If we talk about the moratorium and amalgamation, so Reserve Bank is authorized under section 45 of the Banking Regulation Act to apply to the central government an order of moratorium in respect of any banking company where it appears to it that there is good reason to do so. So this may be on the terms and conditions that the government thinks or they prefer to impose. This period of moratorium is extendable from time to time. However, this total period shall not exceed 6 months. All right, this total period shall not exceed 6 months. In this period, what is the period of moratorium? The banking company shall not make any payment to the depositors, or they shall not discharge any liabilities or obligations to any other creditors unless it is otherwise directed, right? So this is the period of moratorium. Okay, then again, if the amalgamation is necessary to do so because it is in the interest of public or in the interest of depositors for securing the proper management of the banking company, the decision can be taken. All right, then what else? Okay, winding up of banks. The winding up is completely different from amalgamation and mergers. Winding up, right? So a banking company, they need to be able to pay off its debts or to the creditors. It is also required to pay back to its depositors. If for any reason a banking company is unable to meet its liabilities, then it may result in the winding up of the bank. So winding up or liquidation, basically the process of dissolution of a bank. when it ceases to do the business as usual, when it is no longer conducting the banking business. So, a banking company which is temporarily unable to meet its obligations, they may themselves apply to the High Court under Section 37 of the Banking Regulation Act for staying the commencement or continuance of any proceedings against it. The winding up decision is taken by High Court, but if the bank says that it is only a temporary thing, that we are not able to perform our duties, then the High Court may consider the reasons that are provided. All right. So, if the High Court thinks fit, subject to any terms and conditions, the fixed period may be applied. Right. Again, this total period will come under the moratorium. It will not exceed 6 months. If we talk about the winding up of the by the High Court, winding up of the banking company by the High Court. So, the High Court shall order the winding up of a banking company, which is given in Section 38 of the Banking Regulation Act, if the banking company is unable to pay its debts or an application for the winding up has been made by Reserve Bank under Section 37 or Section 38 of the Act, right? And the Reserve Bank is bound to make an application for the winding up under Section 38 if it is directed by the central government. They may issue such direction on consideration of any report or inspection or scrutiny which is made by the Reserve Bank, right? But before giving any such direction, the banking company has to be given an opportunity to make a representation. Like they should be given a chance to prove or to be heard, right? Again, it is open to Reserve Bank. They can apply for the winding up if they see there's a failure to comply with the requirements regarding the minimum paid up capital and reserves, or the bank is not able to carry on the banking business. They can be prohibited to accept fresh deposits, failure to comply with the requirements, anything at all, right? If there's a compromise or arrangement sanctioned, or return statements informations show that the banks cannot pay its debts, then the Reserve Bank may decide for the winding up. If we talk about the official liquidator, so we know that the decision of the dissolution is given by the High Court, but at the High Court there should be an official liquidator. This is given under the Section 38A of the Banking Regulation Act, that there shall be attached to every High Court a court liquidator, that is to be appointed by whom? By the central government, for the purpose of conducting all the proceedings for the winding up of the banking companies and performing such other duties. So, two things. First, every court, every high court shall have an official liquidator, which will be known as the court liquidator, which will be appointed by the central government. All right. So, two things are of importance to us, and all right. RBI can also, or others can also be appointed as the official liquidator. If the RBI feels they can apply to the court under the Banking Regulation Act, right? The any other person on their behalf can act as the official liquidator. All these provisions are there, right? Then, if we talk about penalties, so certain penalties are given under the RBI Act, other penalties are given under the Banking Regulation Act. So, the Chapter 5 of the RBI Act deals with the penalty for violation of the Act. Various violations are there, like for the failure to produce any books, accounts, or other documents, or statements or information which a person is duty bound to make under the Act. Then the penalty is up to rupees 1 lakh for each offense, right? Then for continuing offenses, there's a provision of additional 5,000 for each day when the offense continues, right? So if the banking company, they are not making the correct returns or correct information or documents, or they're providing false information, knowing it to be false, or willfully they're omitting to make any material statement, right? Then they're punishable with this fine plus imprisonment up to a period of 3 years. So this fine plus 3 years jail term is prescribed under the RBI Act. Then, if we talk about the penalties under the Banking Regulation Act, so it is given under section 46, right? Like any false statement willfully made in any return, balance sheet, other document which is required, willful omission to make any material statement is also punishable. Again, punishment is up to 3 years imprisonment, and fine which may extend to up to rupees 1 crore or even both. Both fine and imprisonment can be given. So if the person fails to produce any book or information or giving false information, if any deposits that are received by the banking company, they are in contravention of the Banking Regulation Act, or if any other provision like complying with any requirement or carrying out the terms or obligations, right? Again, when we'll study about these penalties in detail, so under section 47, the offences are cognizable only by the metropolitan magistrate, the judicial first class, or a court superior, right? All of these provisions are given. So these are the important sections, the important topics of this chapter. So when you study this chapter, when you read this chapter, make sure that you highlight these points and you keep in mind these important sections. So that is all for today. We have summarized the chapter, the unit 4 of our module A, and there are many details, but this was only a summary. If you want to learn this chapter in detail, if you want to see all of these things in this information in detail, make sure that you go through the description that is provided regarding the course. So I will meet you again tomorrow, same time, with the next chapter. If you have any doubts or any queries, do let me know in the comment section. And that is all. Thank you so much for attending, and all the best.